tailored for E2 investors and L1 executives. The most serious corporate problems rarely appear in daily operations. They surface when USCIS, a bank, or an investor requests current corporate documentation and the company cannot produce it. For foreign investors and multinational executives operating in the United States, that moment can affect not just the business, but your immigration status. In the United States, failure to file the annual report accurately and on time can place a company out of good standing under state law, with immediate legal and immigration consequences. For E2 investors and L1 executives, corporate compliance is not administrative housekeeping. It is structural immigration protection. Today, I want to explain what legally happens when an annual report is not filed on time and why these failures often surface precisely when your visa renewal or extension is under review. My name is Tapias. I am the CEO and an attorney at Loigica. We advise foreign investors and multinational executives on corporate compliance, governance, and the legal structure required to support banking relationships, operational growth, and immigration filings. There are 4 key issues you must understand. First, what the annual report legally represents. Second, the role of the registered agent and why reliance on it often fails. Third, the real consequences of losing standing. And fourth, why these problems tend to appear at the exact moment when you file an E2 renewal or an L1 extension. Point 1, annual report and immigration link. The annual report is a mandatory state filing that confirms your company's continued legal existence. If your company falls out of good standing, it is no longer in full compliance with state corporate law. For E2 investors, this can raise questions about whether the enterprise is real, active, and properly maintained. For L1 executives, it may undermine proof that the U.S. entity is validly structured and operational. This is not clerical, it is structural. Point 2, registered agent failure. The registered agent is the legal recipient of official notices, lawsuits, and compliance communications. In practice, breakdowns are common. For example, inactive agents, unmonitored email addresses, or outdated contact information can cause these breakdowns. When notice is legally delivered but never reviewed, deadlines are still binding. For a foreign national relying on that company to maintain lawful status, that risk is magnified. Point 3, real consequences. When a company is not in good standing, the consequences extend beyond late fees. Banks may restrict accounts. Financing may stall. And immigration filings may face additional scrutiny. Corrective action requires reinstatement filings, penalties, and formal explanations, which can weaken credibility during a visa adjudication. Point 4, when it surfaces. These issues rarely surface during routine operations. They appear when you file an E2 renewal, when you extend an L1, you respond to requests for evidence. At that stage, timelines are compressed and immigration consequences may already be in motion. That is why compliance must be addressed before it becomes reactive. If you are operating in the United States under E2 or L1 status, corporate compliance is not optional. It is part of maintaining immigration stability. At Loigica, we can conduct structured corporate compliance reviews and ensure annual reports and governance records align with both state law and immigration strategy. If you would like to assess your company's standing before your next filing or renewal, we invite you to contact our team.